such being the position and in the absence of any allegation of the misrepresentation or fraud made by the applicant cannot be permitted to raise the allegation of the misrepresentation or fraud for the first time in the court. Moreover, for the sake of argument, even if we consider that the respondent had prudently entered another date of birth in his service book, as had been alleged, it should have come to the notice of the authorities during his course of service and not after he had attained the age of superannuation after the expiry of the date mentioned in the service book, which was based on the affidavit of the respondent. To the contrary, none of the officials responsible had noticed this during his service period, even during his time of promotions when the service book was required to be inspected by the officials. Therefore, it clearly points out to the gross negligence and lapses on the part of the authorities concerned, and in our view, the respondent cannot be held responsible to work beyond his date of birth as mentioned in the matriculation certificate when admittedly in the service book after affidavit some other date of birth was also evident. In view of the aforesaid circumstances, the applicant ought to have deleted the date of birth entered in the service book of the respondent on the basis of his affidavit, as the applicant had already accepted the date of birth of the respondent on the basis of his matriculation certificate, which was also produced by the respondent. The applicant alleged that the respondent had entered a second date of birth in his service book that a later period of time. The respondent vehemently negated his contention, stating that two dates of birth were entered simultaneously in his service book by the department officials. It is not needed for this court to verify the veracity of the statements made by the parties. If at all the respondent entered the second date of birth at a subsequent period of time, the authorities concerned should have detected it, and there should have been a detailed inquiry to determine whether the respondent was responsible for the same. It has been held in a catena of judicial pronouncements that even if by mistake higher pay scale was given to the employee without there being misrepresentation or fraud, no recovery can be effected from the retired dues in the monetary benefit available to the employee. This court, in the case of Kailash Singh versus the state of Bihar and others, held that recovery sought to be made from the salary of the employees on the ground of alleged overstay in service on the basis of age assessed or considered, despite the fact that the employee has worked during the period of alleged overstay, could not be made.